Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about speculative defenses. Cases that should have gone to the Supreme Court of Canada, but didn't. In a murder trial, Ms. Sorella was trying to argue that she had a defense in that the murder that was alleged to have been committed by her was actually committed as a result of the activities of organized crime related to her ex-partner. The court did not allow her to advance this defense, characterizing it as essentially being speculative and not permitting her to leave the defense with the jury. The question about what a speculative defense is something that the Supreme Court of Canada should weigh in on. Obviously, defenses shouldn't be left with a jury where those defenses are purely grounded in speculation but no real evidence. But at the same time, there are many defenses or theories of the case that are always going to be speculative in some way, particularly in relation to situations where you don't have witnesses that you can compel. People who are involved in organized crime activities are not going to show up as a result of a subpoena and say, hey, yeah, actually I did commit this murder. People who are involved in organized crime activities might not easily be identifiable or even determined where they're located to serve them with a subpoena and compel their attendance in court. And so to raise a defense that is almost impossible to raise essentially leaves a person in a position of having to raise what is effectively a speculative defense. And it should be for the jury to sort out whether or not something is purely grounded in speculation, as opposed to has some realistic possibility of having been the cause of the murder. I mean, that's what we entrust juries to do, to determine the truth of matters. And simply because something is speculative, where it can't be proven because of obstacles in proving it, shouldn't prevent cases from being left with the jury with those defenses for the jurors to sort out whether they accept it as a possibility or not. That shouldn't be the case. And the Supreme Court of Canada had the opportunity really to divulge and delve into this question of what is speculation versus what is difficult to prove. And unfortunately, they missed an opportunity here to make the ability to bring a defense, particularly in relation to serious charges before a jury, far more simple for individuals who are facing complex cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.